Former Supreme Court Justice Kurian is joining India today exclusively. Sir, you must have heard the statements, certain critical statements that were made by Vice President Jagdeep Dhankar about the judiciary, about the Supreme Court. As the former Justice of the Supreme Court and now the head of the Tamil Nadu Committee, how do you see these critical statements, specifically where he's saying that Article 142 is being used as a missile on the democratic forces? He's saying that the judiciary has started to act like super parliament. So these are really critical comments coming right from the Vice President.
With great respect, I'm unable to agree with the Honorable Vice President of India, Mr. Dhankar. I wonder, he himself being a senior advocate who have been practicing before the Supreme Court itself, interpreting the Constitution, how this sort of expressions could come. One, it is not a super parliament. It's actually the parliament, if you read the judgment, the parliament itself has issued a MOP, Memorandum of Procedure, wherein they have prescribed 3 months' time for consideration of the bills. It is the same time frame that the Supreme Court mentioned it very clear, by way of a reminder, because there is nobody above the Constitution. Everybody is under the Constitution, including the court, no doubt about it. And it is the Constitution which has given the power under Article 140 to the Supreme Court of India for doing complete justice. So what is complete justice would depend on the facts and circumstances of each case. But the only rider is, it must be for doing justice. In this particular case, according to me, the court was absolutely right in having invoked, in the particular background of the factual situation, wherein the court was convinced, and everybody should be convinced, because the constitutional process of scrutiny of a legislation made by the people, just as the Honorable Vice President said, that's also a legislation. Just as Parliament is a state legislature. A bill enacted by the, or passed by the state legislature. If the whole purpose of the bill can be defeated by delaying the constitutional process of scrutiny by the governor, who is not an elected representative, is an appointed person. Well, definitely the court was absolutely right in having interfered and reminded the constitutional functionaries, because everybody is a constitutional functionary. The Constitution speaks about the governor's duties and powers. But I would like to add one word: function. That's a constitutional function. It is for him to see that the Constitution functions. Therefore, if he failed to see that the Constitution functioned, then the Supreme Court, being the guardian of the Constitution, was absolutely right in emphasizing what the constitutional function of constitutional functionaries are. Be it the President, be it the Vice President, be it the Governor, who is very high.
So, but one addition to that, not only the Vice President, but many of the ministers and political entities have been also very critical of the judgment that was passed by the Supreme Court of India in context of the Tamil Nadu Governor's Act. And again, referring back to what Vice President also said, that, you cannot instruct the President of India, you cannot issue orders to the President of India. So these are very critical words coming in, especially in the context of this particular case. So do you still find that the order was absolutely as per the Constitution and what was needed?
I must say it was essential. Who said no direction can be issued to the President of India or Governor? What is the constitutional immunity given to them? There is a constitutional immunity that they are not answerable to any court for the discharge of their official duties, no doubt about it. But what is the purpose of exercise of this official duty? Scrutinizing a bill? And even according to the government, because they act on the advice of the government, the government's own advisory MOP says 3 months. Right. And if they take 3 years, that means they have failed the Constitution. Nobody shall be permitted to fail the Constitution, howsoever high a person may be. Right. So if somebody fails the Constitution, then the guardian, the Supreme Court, should step in, and the Supreme Court was right. I would, fourth time I would emphatically say absolutely right in having issued such a direction.
Final question, sir. What we have also seen, like you were part of that historic press conference back 2018. And you had mentioned about that political interferences are there happening with the judiciary. So how do you see this recent loggerhead where the executive and judiciary seems to be at loggerheads with not only this case but several other cases as well, right from NJAC to Collegium? So how do you see that? Is that increasing, and is it a right trend that's happening, that's unfolding?
If you ask me the trend that has been unfolding has been quite unfortunate, because the so-called MOP, which at that time said it was being finalized. I don't think that MOP as to the functioning of the Collegium and the scrutiny thereafter till the process of appointment has been finalized yet. Even the existing MOP has not been followed in many cases. So it has become a situation where there is neither a Collegium system, and the Collegium itself is not in a position to, I don't know why, not in a position to, I don't say not in a position, the Collegium itself is not, not keen to see that the Collegium system's powers or their jurisdiction are protected. Because once the Collegium makes a selection and sends it for further process of appointment, if there is something as per the judgment, if the state is not able to agree with that recommendation, they have to send back for reconsideration. But even after having sent back and the Collegium asserts its views, then there is no other goal. That's like the bill, Article 200 and 201, exactly the same thing. Once having sent back, but the position has been really asserted, then the executive has to act. That's actually the law laid down by the Supreme Court of India under Article 141 of the Constitution of India. The law laid down by the court is binding on all the courts and tribunals, and it's binding on the country as well. And I don't know whether the people who lay down the law itself, when it is being violated, are silent on this. That is very unfortunate.
Thanks a lot for speaking to us. So that was Justice Korean Joseph speaking to India Today exclusively, reacting to the comments of Vice President of India Jagdeep Dhankar, saying that the Constitution gives rights to the Supreme Court to recommend certain things even to the President of India, and he says the judgment in this particular case, the judgment in regards to the Tamil Nadu Governor is correct on part of the Supreme Court, and he also says that the process cannot be used to, delaying process cannot be used to defeat the constitutional procedures. With video journalist Nasir Khan, this is Amit Bhardwaj reporting for India Today from Delhi.